Good morning, Ms. Hammond. Mr. Fox, good morning.
Good morning. May it please the Court, my name is Robert Fox, and I represent Mr. Gross. About 11 months ago, this Court held in the Parra decision that dismissal is the appropriate remedy for any violation of the 60-day deadline of Chapter 123A.
Was the 60-day deadline violated?
I believe it was. The probable cause was found somewhere in the middle of August, and by the time around October 18th, I think was around the 60-day deadline, no petition for trial had been filed.
Well, what about the original petition that the Commonwealth filed? Didn't that indicate that there would be a trial, a request for a trial?
I would suggest that the original request for trial in its original petition was merely a request for relief that lawyers put in their petitions all the time. It doesn't...
So it's a request for a jury trial. They put it in their petitions all the time, and then waive jury trial.
Right, but here the basis to go to trial depends not on the original position of the Commonwealth to bring the petition, but rather it requires first probable cause to be found, and then that there be two qualified examiners who write reports, and based on that, the Commonwealth can make an informed decision about whether or not it wants to proceed to trial.
I have a more basic question. If you'd step back a minute. Did the Superior Court judge have authority to reconsider the decision of the first Superior Court judge who had denied the motion to dismiss without any changes in the facts or in the law?
I believe it did. Under the law of the case, and I do cite this in my brief, a subsequent judge can make a different decision based on changing facts. Of course, there weren't any.
Right.
Probably wasn't a change in case decision, or if there was just an error in the original decision.
But if there's just an error in the original decision, then wasn't the second judge sitting as an appellate court reviewing the first judge's decision? If it's just an error.
My understanding is that a subsequent judge at the trial court level can change a decision of the original judge in the trial court, and I think that was justifiably done so here.
So if you had 3 or 4 judges dealing with a case at different stages, and a lawyer renewed a motion with those 3 or 4 judges, you could have a judge making a decision, a second judge changing that, a third judge going back to the original, and a fourth judge going back to the second judge's position. That's what you're telling us.
No, I'm not. I think by the time Judge Garsh made her decision, the case was then ripe for appeal, which was done, and arguably after the first decision, the lawyer could have sought a 211-3 petition here. Whether it would be granted, who knows, but I think the fact is the case is here, and regardless of which judge is right, and I would suggest it was Judge Garsh, the case should be decided here.
And indeed, I assume if there was a trial and your client was found to be sexually dangerous, you'd be here on the same issue, challenging the motion to dismiss, or the denial of the original motion to dismiss.
That's correct.
Could I ask you, on this record, the record as it stands now, what are we to make, if anything, of the repeated continuances, including some by the respondent or acquiescence in requests for continuance by the Commonwealth, that occurred after the motion to dismiss was originally denied? That does suggest strongly to me that there was absolutely no way that this was going to get tried promptly, within the 60 days of the filing of any petition for trial, even if it had been filed on time. It's a little bit troublesome to me that you come in here saying, terminate the Commonwealth's rights because it didn't file a piece of paper that would have started the trial clock ticking for 60 days, when I have sat back and gone along with continuance after continuance after continuance for, it looks like, something over 2 years. Should that be taken into consideration?
I would suggest you should not. I believe there are 2 60-day periods under the statute. The first, which is the one we are concerned with here, does not allow for continuances for good cause, as does the second period from the time of the trial petition to the time of the trial.
Right, but the overall concern about the liberty interest is how long liberty can be deprived from beginning to end of what is supposed to be this process. And it can be deprived for the original 60 days, and then it's supposed to be deprived for only another 60 days to get all the way to trial. You're asking us to be very strict about that first 60 days when your client has shown, shall we say, no interest in getting this thing tried promptly.
It's not just me that's asking, it's the legislation. I think it's very clear between the different ways the two sections are written that the first 60 days is a much stricter period. And the statutory interpretation, and I don't think it's new law, I think it was hinted to in the Knapp decision that the trial petition has to be filed after the qualified examiner's reports are filed. And it is a simple process. This court has held that it's the 60-day period is the time which determines whether the deprivation of liberty has been violated.
Well,
by
let me pose you this hypothetical. Suppose the Commonwealth files a petition for trial 3 days late, but everybody is all ready, and the case gets tried 45 days later. So it's all done within that total 120-day period that the legislature envisioned. Where's the deprivation of a liberty interest due to the late filing of the petition? The liberty interest, the ultimate liberty interest, is what's the total period, and how do things impact the total period? We've said that in one of our prior cases. And isn't the total period the period from probable cause finding to trial? And I don't quite understand how that has been lengthened in this particular case.
Well, if the Commonwealth had, in fact, filed a trial petition a few days late, apart from the Parra decision, assuming it met the requirements of that, that is a completely different case as opposed to here, where the Commonwealth never filed a trial petition.
I realize, yeah.
And the only reason the issue was brought up is that trial counsel for Mr. Gross filed a motion to dismiss. And I think the Commonwealth is arguing that defense counsel should wait for the second 60-day period before filing that type of motion where...
No, if you file the next day, that's one thing.
Right. And so the Commonwealth has not filed its trial petition, and maybe you can twist the motion the opposition to the motion to dismiss as its trial petition. Still, that came 3 weeks later. There was no showing of extraordinary circumstances that this court required in Parra.
I suppose, in one sense, Mr. Gross, leaving aside whether or not the statute contemplates whether it's there has to be a delay by the Commonwealth until you've got the reports of the two qualified examiners. It puts the petition in a rather damned if you do, damned if you don't. Assuming that it's 3 days late, you file a motion to dismiss. That's denied. You can seek an immediate interlocutory appeal, but that may take quite a long time until it gets heard up here. You file for an immediate release of your client. That's denied. It may take more than 120 days before that gets heard, and then the issue is what do you do in the meantime? You may want to, in light of the fact that the motion to dismiss has been denied, want to proceed to get a trial as quickly as possible, but the two things are going parallel, correct?
I suppose that's a possibility. I think that would be to the discretion of the trial attorney and his client. And that issue does come up, and depending on the issue and the attorney and the client, different decisions are made. But here, it was the decision by trial counsel to seek, he first sought an interlocutory appeal and through the appeals court, which was not able to grant relief because it was result in the ultimate dismissal of the case.
No, I understand that, but then I assume it puts the trial counsel or the petitioner in a difficult position, because either you say, let's continue, let's ask for continuances because I think I'm going to prevail on the motion to dismiss and I don't want to go through a trial, and then, by the time it gets up to the Supreme Judicial Court, there's a record of, umpity-ump months or years of continuances.
Right. From my own experience in the Knapp case here, it came up here very quickly, in 2 or 3 months. And it's a decision the trial counsel has to make, but I think it's certainly a sound decision to seek the motion to dismiss rather than going through trial.
Certainly.
Trial is expensive,
No, I understand.
Yeah.
I understand, but what I'm saying is if you filed a motion to dismiss and while you're seeking interlocutory appeal and while you're trying to get your client out and counsel is not obtaining relief, it seems to me that it's not an entirely unreasonable strategy in the meantime to agree to continuances. And then, then when we look at it post hoc to say, well, you've agreed to continuances.
I would agree with that.
Was there any attempt at interlocutory appeal here?
Yes, to the appeals court.
And I'm sorry.
They denied it because they will not grant interlocutory relief when it results in the ultimate
Right,
dismissal.
okay.
Wasn't there also an attempt to have him released?
There was. The trial court stayed release pending appeal, and
Correct.
I believe the appeals court denied
Pending
the
this
motion to
appeal
stay.
now, not during the 2 years after the denial
Yes,
of
the
initial.
appeals court denied it, I don't remember the exact date, but it was after the case was docketed.
I'm sorry, but motion to dismiss was denied in November of 2002, correct?
Correct.
All right, and you say an appeal was taken from that, or an effort to prosecute an interlocutory appeal from that denial?
Correct.
Okay. And also an attempt to get your client released from custody at that time?
At that time, and there was also, I believe there was a motion to stay, or it was certainly considered by the judge on her decision in the motion for summary judgment. I think she said the case did not require a stay, but she granted one to the Commonwealth to allow them the chance to appeal to the appeals court.
But that has to do with the most recent allowance of, or basically the judge's reconsideration of the denial.
Yes.
Mr. Gross, am I correct that if we agree with you with respect to the first 60 days, we are in essence saying it is not any request for a trial which is filed by the Commonwealth before the receipt of the reports of the 2 qualified examiners is, sort of void ab initio? I mean, it just doesn't, it's meaningless.
That's my position.
And where in the, I can see the statute, but we essentially have to read into the statute that the district attorney or attorney general, at the request of the district attorney, may not petition the court before the receipt and must petition the court within 14 days.
I don't think you have to read that in. I think
Well, isn't that the effect of what you're asking us to do?
No, I think it's to take a look at the clear statutory language, which provides that the trial petition shall be filed.
That just sets the outer deadline, the outer limit, doesn't it? There's a window of opportunity to file it. The question is, is it triggered by the filing of the petition, the original petition, or is it triggered by the filing of the 2 reports?
I think it's a little of each, and I think that's part of the clear statutory meaning. So the qualified examiner's report set the early limit, and the statute talks about 14 days thereafter, which...
Mr.
Says
Fox,
the petition has to be filed within 14 days of the filing of the qualified examiner.
And I think this court hinted at that in the Knapp decision. It uses the word thereafter, referring to the relation to the time of the...
And I take it part of your argument is that you've got to look at the statutory scheme here. It only makes sense if within means after.
Right.
Because there has to be a trial within 60 days of the filing of the petition for trial, correct?
That's correct.
And if that petition were filed at the time that the Commonwealth was filing for probable cause, that would be months ago. So the trial would have had to have taken place before, literally almost, before the qualified examiner's reports were even filed. And that makes no sense.
Correct.
That's your argument.
Correct.
But it's also within the time allowed, within paragraph 14A, talks, presumably, you interpret that within that subparagraph of the statute.
Right.
Mr. Fox, refresh my memory, if you would. If the two qualified examiners report that the defendant is not sexually dangerous, can the Commonwealth still proceed to a trial?
That's a good question. I just had that case in a Section 9.
So that hasn't been decided yet?
No.
But the Commonwealth couldn't come up with its own expert and proceed to trial with a separate expert, its own independent expert?
I don't think that has been decided
All right,
in this
okay.
court. I would think if both qualified examiners were were saying that he was not sexually dangerous, the Commonwealth would not be able to go
Okay.
forward, but that's for another day.
Thank you, Mr. Fox.
Thank you. I rest on my brief. Thank you very much.
Mr. Mark?
May it please the Court, David Mark for the Commonwealth. I wanted to address what I take to be a primary argument of my brother, which is that PARA controls here, and when he says that...
Well, excuse me, could I ask you a question just to clarify something? Do I take it that the Commonwealth routinely includes a request for jury trial in the 12B petition?
I think in our county it actually depends on the assistant district attorney who's doing it. I believe there are some who feel that that's valid, permissible, and do it routinely, and there are others who...
The question is not...
Can I just finish my question?
Sure.
If you routinely do that then, or if some assistants routinely do that, then wouldn't that, and your argument is that that satisfies your statutory requirement to move for trial, then you would never have to file a second petition for trial, and 14B's requirement would be superfluous. Is that right?
Yes, Your Honor, and for that reason I wanted that. That's my second argument. I raised that argument in the brief because Knapp leaves the question open, and I think it's probably wise to have this Court decide it.
But, Mr. Marks, just getting back to that point, if it is permissible to file the request for jury trial with the original petition, does that in fact compress what would be a permissible 120-day period down to 60?
We would have to say no, because for Justice Cordy pointed out, the problem with that is that we then have trial before there's been a determination by the two QEs.
Well, of course, but isn't the whole statutory scheme, which the legislature has laid out, and it's consistent with the language of 14A. I don't mind if you file a request for the jury, whatever you want to do. I don't think it satisfies 14A. The scheme says we've got a problem, you've got to have probable cause, then you get two qualified examiners. Once you've got the report of the two qualified examiners, the DA or the Attorney General at the request of the District Attorney may petition, but such petition shall be made within 14 days.
Yes.
It seems to me that you can't not avoid 14A by filing it at some time before the qualified examiners. For one, that absolutely renders, irrelevant the views of the qualified examiners.
I mean, why have you held this person for, the 45 days to get the qualified examiner's reports if you're saying, no, you don't even need them?
Well, there are two parts to that, actually. But what I would say about Justice Marshall's point is, before I get back to your point, Your Honor, there's enormous force to this logic. This is the very point that Judge Garsh, in her thoughtful memorandum of decision, raised. And as I say, I would prefer to concentrate on the first argument. The second argument is made because Knapp...
So we should decide the second argument, but your real argument is your first argument.
It is. As I say, I think that having said, it seems to me that in effect this Court has really answered that question in other opinions, not only in Knapp itself, which says the question is open and then sort of implicitly goes on to answer it, but the recent case of Parra includes something that suggests very strongly that Chief Justice Marshall's reading of the 14A language is the one that's going to prevail here. So I would prefer to make what I conceive to be the stronger argument here
The stronger argument, just so that I understand you, means what is the relief to be granted in this case?
I'm sorry, say that again, Your Honor?
The stronger argument, so I'm with you, is what is the relief to be granted in this case?
Yes.
That goes to Justice Sossman's inquiry about what happens if everything gets done within 120 days.
So where we start then is the Commonwealth committed a violation of its obligation to file its trial petition within
the 14 days.
Within the 14 days
Okay.
after the QEs had filed their report.
Okay.
What is the significance of that? Does it require the dismissal of the petition? Our argument is no. The significance, if it has any at all, of that request for trial in the original 12B petition is not that it effectively satisfies our 14A requirement. It's a question of notice, and it goes to the question of whether there's actual prejudice to the defendant.
Well, can I just ask you about that? Because I am concerned when we have part of our jurisprudence has been to see it's not really a question of notice, because if we construe the statutory scheme to say that the Commonwealth really is obliged to wait until it gets the reports of 2 qualified examiners. In part, I suppose, given the resources that petitioners have and their counsel have, rather than assuming that the Commonwealth is going to ignore whatever the qualified examiners say, which would seem to me an extraordinary position for the Commonwealth to take, it's going to wait and get a reasoned judgment, and the district attorney may or may not file. Thereafter, let's assume that you have a motion to dismiss, and that's filed, relatively promptly, within a week, or I think it was 2 weeks here, wasn't it?
It was 3 weeks.
3 weeks. So within 3 weeks. And then for a whole variety of reasons, because, it's a matter of some concern to release people where there has been a showing of probable cause. It just takes a long time. One Superior Court judge decides one time, the counsel takes it up, comes back again. It seems to me the whole statutory scheme is off on the wrong footing. If the Commonwealth's position is, well, it's simply a question of notice. Put differently, I think if the Commonwealth even initiates proceedings to have somebody, ultimately, kept incarcerated, I suppose is putting every single person on notice that there's going to be a trial, and that just seems to me to, make a mockery of what the legislature has set up.
Well, put another way, how can it be noticed that there's going to be a trial when you don't even know the qualified examiner's reports may come back that this person isn't sexually dangerous, and you may decide not to go to trial? So how can it, in fact, be true notice that you want a jury trial?
The panel is well ahead of where my argument is. So the answer to that question is that I would ask the Court to look at that trial request in the 12B petition as only one facet of what, in this particular case, would have led the defendant to understand that we were going forward with trial.
And what are the other pieces as opposed to somebody?
Well, there are two. The judge then, the order of Judge Rufo, the probable cause judge, is the defendant is to be held for evaluation and trial. That's piece 2.
But first of all, how could the judge order that? There's nothing in the statute that permits the judge to order that.
I'm not suggesting that the order had the effect of requiring the case to go to trial. I'm saying consider that as another indication to the defendant and counsel of where this case is headed. You have a very strong
but the question is that there are plenty of indications, the nature of the offense, the fact that the Commonwealth has commenced proceedings, there are plenty of indications, but it seems to me that what the legislature has set up to say, until you get that, and you've got a 14-day period, the Commonwealth has to make a decision. By the way, it's a pretty short period of time. Given the way decisions are sometimes made. But until that period of time, until that 14-day window, the defendant is not on notice, no matter what happens beforehand. There may be lots of indications that the defendant can guess, hypothesize, or even strongly believe that the Commonwealth is going to proceed.
Which is another way simply of saying that notice means a particular thing in this case. So in some sense, we're talking past each other, because I'm saying that the question is whether the error that the Commonwealth committed here requires the dismissal of the petition.
Right.
And I'm saying that look at the actual prejudice, if any, to the defendant. The other piece of that, to continue.
Can I just interrupt
Yes.
you with that? My concern, obviously, is we have this case and then we have what the ruling means in other cases. If, in fact, it's going to come down to a fact-specific inquiry every time, and where there's a clear violation of the statute, let's assume that there is, that just embroils all of us, in an endless merry-go-round. So you have to tell me why, in this particular case, this will not be a precedent for the Commonwealth to do this endlessly. I filed a notice, I didn't do this, but if you look at the facts, that's exactly what we've tried to back out of.
Yes, no, I'm aware of the force of the series of decisions that
Sure.
this Court has issued on that. I absolutely understand where that's going.
But what makes this case different from, let's say, like circumstances of if the Commonwealth did this again? You have district attorneys, assistant district attorneys, perhaps believing in good faith if they did that, they didn't have to file another one within 14 days, because there's nothing in this.
I don't even know that, and nor am I representing to this Court, that we had a prosecutor here who was operating on the assumption that he didn't have to file the trial petition.
We don't have any.
I don't know.
We don't have any indication one way or the other.
Right,
but
there's
I'm gonna
nothing in the
give
record. All we know is that he missed the filing deadline.
And what we know is, I'll give the Commonwealth the benefit of the doubt that he wasn't deliberately violating the statute.
Right.
I mean, it's not as if he filed it 5 days later, correct?
Right.
It was 3 weeks later.
Right, well...
it was never filed, actually.
Well, I mean, it was brought to his attention in a
Right.
very...
And that's right.
yeah.
Your
So
third
to go back-
facet, I'm sorry, your third facet?
Well, again, I've been slogging away at this idea that it doesn't... I need to address Justice Marshall's point, because I think it's maybe the strongest argument for the defendant in this case, which is, do we create an awkward precedent that then, regardless of the equities in this case, what kind of precedent are we creating? Do we create a morass when this Court has tried so hard to create sort of bright lines and rules that are easy and clear to follow? I guess my answer to that has to be that this case is just an oddball case. You have a unique set of circumstances. It's not likely to arise again. I don't think, particularly if there's an announcement from the Court that, no, the idea of filing early isn't going to wash, you really must file your trial petition subsequent to the reports and within 14 days thereafter.
Mr. Mark, do we have any reason to believe in the record that this is an oddball case?
I think the answer is yes, Your Honor. I mean, the facts are what they are. It's certainly not.
Now, let me put it this way. In your answer to Justice Cowan, who asked, is there a routine request ab initio, you said it's not formalized, but more than one,
But that point will be taken care of if this Court indeed announces that, no, you really can't.
But we're going back to 2002 here. Wasn't the original decision 2002?
Yes, that's
So
correct. Well, the original decision on the motion to dismiss was November of 2002.
We've got 4 years of SDP cases, and I don't know, I mean, as I sit here, I don't have any indication that this is the only one where the Commonwealth has sought to proceed without a
I think where I think I've maybe not directing the Court where I need to is the idea that the appeals court had in reversing the decision of the lower court judge dismissing the petition, which is that we're in the Gagnon universe, not in the Parra-Kennedy universe, and that in those circumstances, I mean, that itself is a sufficiently bright line, maybe, that we don't run into the problem that you described. The question is a liberty interest infringed? If the answer is no, then a lesser sanction, if any, is appropriate, but not this automatic dismissal of the petition.
And you say a liberty interest was not infringed.
Correct.
Because this all occurred ultimately within the time frame of the statute.
Yes, that really gets back to the appeals court's opinion and the underlying logic, which I hope to unpack a little bit if I have some time to do that.
What type of lesser sanction are you suggesting?
I think I would answer that question the way the appeals court did, which is a lesser sanction is appropriate where the defendant has demonstrated prejudice to his case, and in this case, he didn't. There's no prejudice to the defendant. This is the defendant quite reasonably seeking to take advantage of a procedural rule to have the case tossed out. That's absolutely his right, and he should be doing that.
Well, procedural
Bravo to
rule,
counsel.
but it's more than a procedural rule. There's no authority to hold someone beyond 60 days unless a petition is filed. Where's the authority? He's being held illegally.
Our answer to that is to look at the structure of the statute. There are a series of provisions. The appeals court, in a now famous passage in Doobie, describes it as in order to move the petition along, the Commonwealth has to demonstrate with increasing rigor at each step a justification for holding and continuing the case. We had met all of those obligations. So that part...
But you hadn't met them 3 weeks after. I mean, that's the 20/20 hindsight of every time you can say all of these procedural, all of these requirements, not procedural, all of these requirements, it's perfectly fine to ignore them. I mean, the nature of the appellate process is such that you're going to run through another 60 days pretty quickly, correct?
I'm not sure where
I
you're
mean,
going with this
you may
question.
or may not get the trial started within the 60 days if the defendant is...
Well, that's absolutely true, but I don't know that I'm not sure I see why.
Well, because it puts the petitioner in a really lose-lose position. Either the petitioner has to go forward with the trial, notwithstanding the fact that he or she believes that they are being illegally held because they want to get it resolved, or they get told on appeal, well, you agreed to a whole group of continuances.
I don't know that I would say lose seems to me wrong. For one thing, here, for example, the appeals court expedited the appeal. So yes, as a matter of fact, you're right, he continued to be held. But had he prevailed in the appeals court, the additional time that he was held would have been modest as compared to exposing himself to a trial. I mean, that's still a good deal for the defendant to avoid the trial entirely and have spent some additional months in custody, but the result of that at the end is you get an appellate decision saying you are, the Commonwealth has made a fatal error here, you are now released. That's not a bad situation for him. I don't think that's lose-lose.
Thank you,
My
Mr.
time is
Mark.
up.
Thank you.
Thank you, Your Honor.